But now, I want to ask a question. Because people keep saying, because of that affidavit, whether it's amended or not, it's still life. Now, the matter was not heard, even before Justice Okorowo. By the time they came to Justice Peter Lifu, they had amended their affidavit to say intention to defect. So now, is it still possible to take the affidavit from Okorowo's court and then apply it to any other court like the Justice Emmanuel Obile's court? I want us to have
an affidavit is
yes.
a public document.
Okay.
And it has universal qualities all over the world.
Okay.
That's why the offense of perjury is treated as criminal.
Okay.
The matter may be a civil matter, but when perjury comes in, it takes a criminal look because intentionally. But for you to have a crime established without an intention,
okay,
nobody commits a crime by accident.
Okay.
So there are consequences. I would say consequences for withdrawal of suits at some point. If you come to court and of your own volition file an affidavit and it has been served on that party, then suddenly come back to retract it. In every matter where your face shows up, you could be confronted with those facts. The onus is on you now to disprove it, and then there are consequences for saying one thing now and coming back and say next time.
That's a matter for the court.
I'm just trying to land somewhere.
Okay.
It's either way.
Okay.
The law does not allow you to approbate and reprobate and walk away.
The law does not allow you to amend your affidavit.
You can amend your processes, but not your affidavits, particularly when there are material facts. Now, if you come back, anywhere you come back, even if it's a normal criminal trial, anywhere you show your face in courts,
okay,
anywhere you show your face in courts, any party can use it against you.
Okay.
You'll be put to test to track those things.
So the condition is if it's a criminal matter.
No, it's not only when it's condemned. I said even the criminal matter, because you are put. Look at the man puts his character. That's what we call character evidence in law. I can't steal. Oh no, I'm a pastor or I'm a bishop. This thing you're saying I cannot do it. You put your character into test.
Okay.
Now the burden will be on you to prove for the court that character evidence. Now you cannot come home. All right, so because you're now a pope, you're a Saint Oby, so you cannot do this, you cannot do that. It's now incumbent on you to prove that. The burden to prove that. Now, at the roots of all of what we do in courts, particularly in civil trials, is the issue of the burden of proof.
Of proof, okay.
Why does it lie per time? The burden of proof can be here on this my left lap in the particular matter. As the matter progresses, and I'm able to push the matter to a point where it moves over to that side. The other party has a burden now, we have shifted the burden, right? It keeps moving back and forth, particularly in criminal trials.
Okay.
Now, for civil matters, it's on the preponderance of evidence. When they bring evidence that is heavy, for criminal matters, it's proved beyond reasonable doubt. That's a bit noble or said there, right? But here, it's the preponderance of evidence. So once you have brought your character into issue, people are bound to question it. So the courts have a duty to hear everybody.
Okay.
If for any reason you defected, you said so in affidavit and now come back and say I did not defect, it's for you to prove.
Yeah, but it's a different, no. See, it's in a different court.
Yes.
It's in a different court.
I said he has a universal character.
Wait. Somebody said this, and I picked it.
Yes.
He said you can't use an affidavit meant for another court where processes have, maybe the case has been dismissed or is no longer live, and then, apply it to another court, particularly when the person who swore to that affidavit has taken leave of court to amend the affidavit. I also hear of the Evidence Act, which says you can also amend your affidavit.
You can amend the processes. It's part of our law.
Processes, affidavits is also part of the processes.
I said, I'm agreeing with you.
Okay, my brother.
But you don't retract an assertion.
Okay.
Right? For instance, today in court, I was leading a witness who said he lives at number 29, some Rumocholo, at Alo. But when they put him in the witness box, while I was leading him, he said 49. So the judge had him. Said, judge asked, is it 29 or 49? He said, 49. But in the process I filed, he told me 29. Okay. So he said right there, the judge had the discretion to correct it in our records.
Okay.
I said 49. It's typo error. Those things are doable, even though it's witness deposition on oaths. minor things, they don't go to an issue, all right? But when they make fundamental issues, and I don't know that lawyer that said you cannot use an affidavit used in the... Look, I have a matter that was started before my mother was born. I came to inherit it. A land case in the game. My mother was born in 1944. That matter began in 1932. Why is it affidavit evidence? One time he used it to kill the mother at some point. He used as arrest judicata. And when the appeal court disagreed, Justice Pastor Chalon of blessed memory, read the judgment in Port Harcourt here. We're back. We've been back in the last 15 years we're in court. The affidavit that was sworn at that time are being used. So when people say you cannot use affidavit, mind you, the suit numbers are not even the same again. If most of the parties are even dead, the original parties are dead. But the affidavit that was sworn at that time are useful now. So when somebody says that the affidavit that has been sworn to cannot be used on a matter,
yeah, because you chose to retain the affidavit. I give you an example. You have a passport. You know, in those days there was a time that you don't need to appear before immigration service to obtain your passport. It could be done by proxy, you know, through somebody sending your passport picture and your details, and then before this, what do you call it, the e-passport, you know, where you need to be present and then take the pictures and all that. Exactly. Now, maybe you had your date of birth, or like me, the person who prepared my passport by proxy made a mistake and said I was born in Isukwato, because she's from my place, and so she assumed without asking me, and then that's what my passport read. But I was born in Enugu. My records are still in UNTH, Enugu. Are you getting me? All my records, even in school.
You were born at Jobota.
No, not really. So all my records show Enugu, but my passport is showing something different. Now, I was advised to write the immigration service and then correct it, because, I mean, in future it could affect me. So, in that case, well, I don't think anybody will hold me liable, because it was not intended, you know, to deceive the public. But anyway, we'll still get back to that issue of affidavit. But let me say this. There's been a major issue in the whole political and legal crisis. The issue of who is the authentic Speaker of the Assembly, and to a large extent, who are the actual members of the River State House of Assembly, in line with the provisions of the 1999 Constitution as amended. Some are of the opinion that it was one of the issues decided by Justice Omotosho of the Federal High Court in that judgment, and also upheld by two separate courts, appellate courts. Recall that Right Honorable Victor Okojumbo, of course, he has the backing of the governor as the Speaker of a three-man assembly. But that is contrary to the decision of the appeal court. After he had obtained the court judgment from Justice, is it Wali? Yes, from the River State High Court. And then the Amehule and co. also went to the appeal court and challenged that judgment. With the judgment, the court said that Justice Wali had no
jurisdiction.
I think Wali, had no jurisdiction.
252
of course, which means they invalidated even the speakership of Okojumbo. Yet, Okojumbo still functions today as the speaker that the governor has...
In the matter that was decided by the appeal court in December 13, 2024, who is the speaker there? It's Okojumbo.
The matter decided?
Yes.
Which of the
Justice
matters?
Booker, the one that they trashed the judgment of Justice Abdul Malik Joyce.
Yeah, so what was...
The man whose name is there as Speaker of the House Assembly.
It could be,
no, let me tell you how it works.
Like you said.
Let me tell you how it works.
Whatever title you're giving,
let me tell
that
you
is
how it
what
works.
it remains until another...
Let me
so
tell you
the
how it
question
works.
I'm asking is... What the question I'm asking is, because if you...
No, you're referring to an appeal court judgment that trashed Charles Wali's judgment.
Exactly.
Right? Good, and said, look, the last judgment in time in the court is a law.
Okay.
It takes precedence over everyone.
Can you give us, you know,
those are
insight
judgments.
into that matter?
Any judgment that, for instance, the appeal court is not the final determinant of these issues. We have the Supreme Court. But at the level of appeal court, let's say appeal court Makurdi Division gives a ruling on Monday. Today's Wednesday. Similar facts, same parties. But the division goes ahead and gives judgment. That's the judgment.
Okay.
That's the one that is relevant in law that you can refer to.
Okay.
The one in that place, let me use the word again, overtaking my friends. So it's only the Supreme Court that has the locus that says the thing is final. Because no other court exists after the Supreme Court. After the Supreme Court,
So even between the two court of appeals, only the Supreme Court can come and say, this is the one
yes,
that, okay.
in the final analysis.
Yeah,
So
okay.
all of those issues about, use the word determination, Motosho did not determine the issue of speakership. It was not in contention for him. The governor will withdraw his counter affidavit. Even Edison Ogrenyo here did not file any counter affidavit. So issue of who is speaker or not was not before him. The man that filed the suit at that time, filed us in the name of Speakers of Assembly, Mats Amehule.
No, if you...
No, listen, let me land.
Go ahead. Yeah.
When they filed us on November 29, 2023, he filed as Mats Amehule as Speakers of Assembly. Nobody was contending with him there. Nobody brought the issue of defection before Joseph Motosho. I never saw it. He had this problem on the radio, maybe on TV, read in newspapers, but he never saw it as a fact before him. And in law, a court cannot go into forum shopping.
Okay.
Cannot go into what they call ambulance chasing. Okay. You can't go and enter an arena of conflict where issues that have happened are not to acknowledge, are not pleaded before you. You can't go and bring what you don't have before you and make it determination. So no determination was made on the issue of speakership or membership of the House of Assembly. It was not part of what was for the House.
It was not part of...
What was for the court?
What was before the court?
Before
but with the Court of Appeal judgment, this one I have here, the one that upheld Omotosho's judgment.
Dated in October?
Yes.
Yes, and I've said the judgment for appeal court, it's in Abuja.
Yeah, the court made, hold on, the court made it clear that Martin Amehule's speakership is not even in contention.
I'm saying it was not in contention because it was not before the court. It was not before the court. So the court was right to say so.
Yeah, so.
Amehule filed on November 29 before he defected December 11.
Okay.
The person that told the court, look, he defected, pulled out. So that fact was not before the court.
So if the person that was supposed to tell the court that he was no longer speaker,
yes,
pulled out.
Yes.
So what does that mean?
No, listen, see, I just give the background now.
Okay.
That judgment was valid until Justice Booker led that panel sat in December. The last time the appeal court spoke on those issues concerning Rivers State was December 13.
Okay.
And that's with that ABJ, CA, blah, 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 1303.
I have that, yeah.
All right? That's the last judgment.
Okay.
And as far as I'm concerned, even that court did not go into determining who and what were members or no members. It nullified that judgment because it said the Federal Court had no jurisdiction to go into state budgets, to question state budgets. A court can only go and question things that are within a jurisdiction. State budgets are state laws. All right?
Okay.
When it comes to federal laws, you can go there. But a federal court has the jurisdiction spelled out in the Constitution. State courts have their own jurisdiction spelled out. That's why even this amendment that came and having this amorphous argument about declaration of membership of House of Assembly or when there's a vacancy in office of governor, deputy governor, it creates some kind of confusion. Before now, it was state high court. Normally, a state high court has powers to adjudicate over issues of that state.
But those things have been...
I'm coming normally. Now, the federal court has a national spread, we agree, but the issues are completely within the spectrum, purview of the federal court.
Yeah.
Things like immigration, defense, currency, all right? No state high court will go there and say, this, naira, this, you can't do that. It's not within a province. So the court is confined to the space of its jurisdictional powers. Outside of your jurisdiction, you don't go there. Whatever, and the law will say, no matter how well a process is conducted, a procedure is conducted, if it has no jurisdiction, it collapses ab initio. It goes on the issue. So the court first must seek to know if it has jurisdiction to go into a matter. And the kind of things that confer jurisdiction are, apart from the law setting of the court, even the parties that come for the court. The parties that come for the court also determine jurisdiction. The issues before the court also determine jurisdiction. So all of that is what most courts, and I'm sure that the reason why probably when we began this conversation, just so believe withdrew was because lawyers on the outside, they have not brought his notice or gone ahead. But we told him, my lord.
So they didn't do that, and so the man had to take a decision.
No, they did that. People drew attention to the fact that, look, the matter is already pending at the Supreme Court and we're adjourned for judgment already.
Okay.
And maybe whatever.
So the other party...
No, even if you're the one that brought it, if somebody raised an objection and the judge is minded, so you don't argue.
Wow.
You don't argue. So you don't have this back and forth thing. Law is a disciplined profession. You cannot deny the fact that there is a matter at the Supreme Court that have been adjourned for judgment. All right? The Supreme Court can
Which means the matter before the Supreme Court, like you said, probably they are similar to that before Justice Oby Ndukwe.
Yeah, in course of speaking, persons are part of filed processes.
Okay.
You don't know what they filed. All right? Now, the issue that became a bit controversial as people are like bothered about was the governor withdrawing on grounds that budget 2024 is spent. There are other issues. When the Supreme Court comes to that ruling, we'll know. All right?
Okay.
Now, we'll now know whether those are live issues. For instance, the National Assembly was trained not to go ahead to take over the powers of House Assembly. Did they do that? They did not do that. And they cannot conduct elections. Did they do that? No. So all of those is not there now. Okay, so
of course, there was also an order saying that
it should not
the
touch.
it should not present or touch
the
and even
considered
present the
fund.
budget
Fine.
except
Yeah.
to the assembly led by Martin Amehule. Probably that's the one you also expecting
Yes.
the Supreme Court. But let me also read from the Court of Appeal judgment, which the one I have here. The court said in its wisdom, I think page 23, that should be either Justice Okonoma, I can't remember, but it says the appellant.
Is that the lead judgment?
Yeah, that's the appellant.
The lead judgment.
Yes, the appellant.
Okonaban read the lead judgment.
No, not the lead judgment. I mean, not Okonaban. The judge, I think that's Joseph Olubumi K. Oyewole.
Okay.
He said the governor, who was the appellant, did not place anything before the trial court, whether the second respondent has been lawfully removed from the office as speaker by the votes of not less than 2/3 majority of the members of the Rivers State House of Assembly pursuant to section 92 subsection 2C of the 1999 Constitution as amended to warrant presenting appropriation bill to a forum other than the Rivers State House of Assembly presided over by the second respondent, Amehule. Now, this is where the court, when people say, oh, no, the court didn't make any pronouncement on the leadership of Amehule. And some persons tend to disagree because of this. Well, we'll just have one or two more.
Let me clear that.
Okay.
Again, with respect to those who probably think the court made the pronunciation, Amehule is the one that fired us to that speaker. I keep saying this. Now, again, the judge just said the governor had no defense, has no counter there, right? So the court is not aware of any defection. At the time that judge was speaking, there's not like defection before the judge. So the judge had to go back to section 92, talk about the removal of speaker.
And that is the only way a speaker can be removed.
No, when the speaker defects, he loses his seat. That's a different section of the law.
No, removing a speaker.
No, listen. Section 92 is about removing a speaker in a normal house assembly.
Okay.
In a normal house, right, there's no crisis.
Like what we have in Lagos.
Lagos, yes.
Okay.
You go to section 92. But when it comes to defection, the speaker cannot even be in a position to say, I would give effect to 109 sub 2. When the defect, first and foremost, a member of House Assembly first before he became a speaker. So if he defects, you lack the locus to sit down and say, well, it cannot be a judge in your case. All right? Section 92 speaks to removal of Speaker of House Assembly in a normal setting. Section 92 is talking about quorum in a normal setting. That same constitution is not ambiguous when it says in 102, if you open your phone and check, you see that it says the House can sit validly, even with numbers depleted. The same constitution says 96 that the quorum must be 1/3 of member sitting. Says in 102 that regardless of the numbers, and that section of the law has been interpreted in the Pelon's case. So those issues are simple and straightforward. Before Justice Omotosho, there was not like defection. He had no facts. Maybe read in the news, like every other person. But there are no facts for him, so he cannot go and wait there.
No. I beg to disagree. Hold on.
Yes.
Sorry. Before Edison withdrew his, resigned his membership of the assembly and all that, he informed the court.
Which court?
The court, the Federal High Court, that he had declared the seat, because that's actually the major issue.
No, wait, which Federal Court?
No. Omotosho, Justice Omotosho.
No.
I'm coming.
Check your facts.
No, hold on.
He didn't file anything.
Okay, hold on. Now, on Edison said he was speaker. That was that he declared he had been elected speaker. That was October.
By a court order.
No, was it a court order? Not that he was elected.
His colleagues elected him and the court gave him
his colleagues
leave.
elected.
Yes.
You know, when
the colleagues would not defect.
No, he said, that's not what he said. He read it out and said he was elected by either 24, 22 members. Hold on. And that was on the 30th of, 31st, after the bombing of the State House of Assembly. The same day, the Amehule and co. suspended him and 3 others, okay? He came out and said he's been elected by 22 or 23 or 24 people, colleagues of his, as the speaker. That was then. So about maybe in a space of 1 month and on the 11th, the court was also told that the governor had gone ahead, in spite of the orders made, injunctions made, to present the budget to Edison. Now, don't forget that the action of the governor was premised on the fact that Edison had declared the seats of those lawmakers vacant as speaker, whether by a court order or whether by a ruling or whether by his colleagues electing him. It was clearly stated that why this move had to be made was because these people are no longer lawmakers. Because even the governor said it at different TV appearances.
Okay,
where he said, hold on, I want to just where he said that he does not recognize Amehule and 26 others as members anymore, not because there was a pronouncement of the court, but because of the actions of Amehule. Even Okojombo, in the suit before Justice Wele, he also claimed that he emerged as speaker after Edison resigned his membership, which means his own speakership is premised on Edison's speakership, which, of course, the court had said, no, Edison was never a speaker in the eyes of the law. Of course, we are still waiting for the Supreme Court. So now my worry is this. Where does this actually lead us to? A situation where even the Court of Appeal, not one, not two, chided the governor for disobeying court judgment.
Let me correct some things.
Okay.
So I would overflow this issue.
Okay.
The appeal court is acting, quote unquote, in ignorance of the facts.
The appeal court?
Yes.
Quote
me.
He said the appeal court...
Federal court and the appeal court acted in ignorance,
of
the facts of defection. It was not before them. So they were dealing with a normal assembly of 32 members. So that can only 4 people, that can only 3 people seats. When they have the facts of defection before them, the reasoning of the court will be different.
Okay.
When they have the facts of defection before them, the conclusion of the court will be different. It has happened many times before. A court is bound by parties' pleadings. It's just the parties are bound by their pleadings. It's what they bring for the court. Even if a judge were to be alive at the scene of crime, he will not act like I had it, I saw it.
Until the thing is brought
if the
before.
prosecution is unable to prove it before him, it no concern him.
Okay.
This is as simple. Our law is not that complex.
Okay.
A court will not go and say, I had on TV, I watched. No. Whatever the governor has said, whatever it has said, as far as the court is concerned, until the facts are before them, the presumption is that the House of Assembly is an institution created by Section 90 of the Constitution. Right? It has, for Rivers, it has 32 seats. For other parts of the country, different numbers. Now, the quorum of Section 96 is built on total number of seats in that particular legislature. So no matter what the internal crises are, when it comes to determining the issue of vacancy of the seats, arising from death, arising from resignation, or whatnot, this is straightforward. When it comes to death, nobody better to go and say, go and INEC will fill a by-election when the people puts a notice. All right? When it comes to defection, it's an entirely different ball game. Moreover, what I've seen is that most times, for political reasons, the presiding officers who did not defect will not give effect because the man that defected came to their party.
Okay.
And that happens severally.
And that
does not mean that doesn't mean this is right. It's not right.
Okay.
The law should not be used the way manner to play politics.
It's only the court that can actually.
No, where there is a contention. Okay. Otherwise, the law says you shall vacate.
But there's a contention.
I'm coming.
The people you said they didn't defect.
No, we'll get there.
Okay.
The law said, in Abegude's case,
okay,
nobody will bring any judgment here that will say Abegude go to the back. No. You must bring facts to show that, look, what the speaker has said does not apply for this in this case. And the onus is on you to prove that. Okay. Right? Now, let me tell you something. A lot of people also have not read. I've had people argue membership. We're not discussing membership of political parties. Some people are saying for you to show that the man that's affected, you must go and sign his word. No, those are the issues. The actions you take.
Yeah, because I was going to ask you, what do you define as defection?
No, the actions you take.
In line with the Constitution.
Yes, when you move for a party that sponsors an election to another party, and then all those provisos listed there are not present.
So let me ask you a question.
Yes.
How do you move? Is it physical movement? Is it not a procedure, a process?
No. I said, you go and read Abegude's case. The Supreme Court was not interested in a long grammar. The facts were proved that the man had moved to the Labour Party.
Okay, it was the court.
There
was evidence before the court.
He wrote that
he had moved.
Moved.
Okay, that's fine. I think that answers that question. So we'll probably wait until the Supreme Court does justice to the remaining cases, and then we'll take it from there. But let me ask you just on the last note, something away from the legal, because sometimes it's good for us to also get our people, carry them along, because law is not, I'm not your legal friend, I'm just your normal friend. So what do you think is the way forward now? Because you see, we heard that PANDEF, the leadership of PANDEF, set up a committee, to interface with the Governor Fubara, and the Minister of the FCT, Barrister Nyesom Wike, to see how they can reconcile, like, a political solution to the crisis. Are you of that view? Do you support that? Or you think it's also unconstitutional, like some said about the 8-point presidential resolution?
As a lawyer, I'm not sitting here and rubbish the judiciary. The issues are before the judiciary. I've never believed that political solutions can solve it.
Okay.
Never believed it.
Okay.
After the first time the president tried to fail, no, why? Because in politics, sentiments, emotions will come in, but the law will look at the issue like this with clear eye. So the point they could reconcile would have happened. Now they've crossed the Rubicon. The justice system is such that, and I tell people to be a bit wary.
Yeah.
When you do some things, and in my village, you don't take a man to police always. They call police. He has named they call police my place, like cutting somebody with a broken bottle.
Yeah.
It will heal, but the scar will be there.
Okay.
Now, maybe what you did in the police station is to press for your rights, right? Yeah. But the system locally has an adjudicated process where chiefs can intervene. But if you have crossed that boundary to get the police involved, that means you have brought government in. Even when the matter heals, the scar will always remind the person that this person, sometimes it becomes transgenerational. Some families don't talk to other families because somebody took their grandfather to
So you are not in support of the peace talk?
No, I can't be in support of peace talk when the matters are fought at the courts.
We allow the courts to exhaust.
Yes, I'll be sabotaging the justice system. As
and
a lawyer,
do you think it's possible for peace, reconciliation, even when the courts have given the final judgment?
No, let me say this.
Because we can't be sure. The law is blind.
No, let me say this. When parties are before a court, the parties agree and say, we are talking outside, we want to settle.
Okay.
The court can give you leave.
Leave. Okay.
The court will not strike matter out because you said you are settling outside.
Okay.
When you are done with the settlement, you come back to the court, I've settled on two terms. The court can enter those terms as judgment. It's called consent judgment.
Okay.
The bad news about that is that you cannot relitigate.
Okay.
You cannot come back and say, the talks broke down.
Yeah.
Court agreed, this other party is not doing this. And you come back. The court say, no, the door is closed. Right? That's the danger of taking matters out of the court, that you get in your local way.
Wow. Right?
So
this is really.
If you go out of the court, it's your liberty.
Okay.
But when you go there and assuming without considering anything goes wrong, and you come back and the court and say, okay, this is the agreement, the consent judgment, you that had lost out, you cannot come back to the court and say,
okay,
you have closed the doors forever and ever for yourself.
Okay. Wow. Thank you so much, my friend Barrister Sogbeye Eli.
Mr. Sogbeye Eli.
Mr. Sogbeye Eli. We know we are not lawyers, so we always put barrister, but I know it's Mr. Sogbeye Eli Esquire.
In Nigeria,
lawyer, politician.
Mr. You're called to bars, a barrister and solicitor. So why do you not solicitor?
Okay, so people need to understand that you don't need to put barrister.
It's Mr.
It has to be Mr.
And barrister will be chief, so you can put chief when I become a chief.
Chief. Should I put chief Mr. or Mr. Chief?
No, when I become a chief, it's just chief.
So I dropped the Mr. Okay, so for now, it is Mr. Sogbeye Eli, lawyer, politician, public affairs analyst. I mean, he's done justice to today's topic, and then, in fact, we can't thank you enough, my good friend. And like you said, we'll wait to see what the Supreme Court makes out of this whole thing. But
heavens will not fall.
Heavens will not fall. And while we are waiting, we pray for peace to reign in the state. Thank you. And God bless you.
Thank you for having me. God bless you, State.
Thank you.